When Gerald Stanley's trial began in January, critics were unhappy with the makeup of the jury. Mr. Stanley, a white man, was charged with killing Colton Boushie, who was Cree. Mr. Stanley, of course, was found not guilty. Critics, including Colton Boushie's family, have suggested that outcome could have been different if the jury had been more diverse. The jury appeared to be all white. Mr. Stanley's defense lawyer was able to achieve that makeup by using peremptory challenges, which allows lawyers to dismiss potential jurors for any reason. Now, the Liberal government has announced plans to do away with peremptory challenges, saying it will improve fairness in trials. But Solomon Friedman says it will do the opposite. Mr. Friedman is a criminal defense lawyer. We reached him in Ottawa.
Mr. Friedman, it would be helpful if, first of all, you could explain how peremptory challenges actually work.
The peremptory challenge process allows both defense and Crown counsel to challenge a number of jurors without offering any reason or justification.
And what does that lead to? What's the purpose of that?
The purpose for that is it allows counsel, although they may have limited information about jurors, to attempt to select a jury that is representative.
So why do you disagree with the government's proposal to get rid of them?
You know, this proposal is really a cruel irony. It comes right on the heels of the Colton Boushie verdict, which of course led to great dissatisfaction. And the irony is that very often, in my experience, defense counsel use peremptory challenges to ensure that the jury is actually representative of the community, because of course the jury pool itself, that is, the people who juries are drawn from, has been found to be, both by the Supreme Court and by independent reports, to be unrepresentative. That is, it's overwhelmingly white, middle class, and not representative of the accused person. So we use peremptory challenges to challenge individuals to get a more representative jury, and we're losing that ability.
Colton Boushie was the victim. He wasn't the accused. Gerald Stanley, a white man, was the accused in that trial, and he had what appeared to have been an all-white jury. How is that fair?
Well, the true issue is that Indigenous persons are tragically overrepresented in the justice system, and they're tragically overrepresented as accused persons. So you remove a protection because you don't like the outcome of a particular case, and the ripple effect of that is that for Indigenous persons who are before the courts, when their liberty is in the balance, you don't want them judged by a jury that is not representative of them. The idea is to have a jury of your peers, that is, a jury that may have the same life experiences or similar social experiences to you, and be able to put themselves in your shoes and understand, not just in a legal way, but in a factual way, in order to return a true verdict. We're losing that with the end of peremptory challenges.
The idea from this, though, is that Colton Boushie was the one who was judged. His behavior, the behavior of his friends, in very many ways, as so often is the case with Indigenous people who are the victims, is that his behavior and he was the one who was on trial. That's why the argument has been, and that there would have been a more fair trial had there been Indigenous representation on that jury, and there wasn't.
The jury system takes out, generally speaking, the political ideology or social ideology out of the process and allows a jury of one's peers to judge the facts dispassionately. Of course, the facts will always be the subject of debate. The defense will see it one way, the Crown will see it another way. It's a fundamental pillar of our democracy. In fact, it's guaranteed by the Constitution to have a trial by jury for serious offenses. The question is, you want that trial to be as fair as possible. And there is no question that although in this case, of course, the victim was Aboriginal, in the Boushie case, Aboriginal people are over-incarcerated and they're over-represented in the justice system. And we're removing one tool that allows us to sort of have that balance. And it's not just for Indigenous people. I know that peremptory challenges are used to attempt by defense counsel to get racialized people, minorities, disadvantaged people, socially and economically disadvantaged people, because they can often empathize with the plight of the accused.
Can you give us an example of that in experience of yours?
Sure, and I'd say that I have experience from the defense side and observing the Crown side of this. In the last major homicide trial I did, where my client was a racialized person, I know defense counsel was doing everything they could to get young racialized men particularly on that jury, and every single young black man was challenged using a peremptory challenge by Crown counsel.
This is the argument that Justice Yakabuchi gave in his report about why that there were so few Indigenous people on juries, is that, first of all, they have to come very long distances in order to be on such juries because of where their communities are, and that their experiences with the justice system have been negative. They don't trust the system. So this is behind a lot of it. So if it's so difficult already to get, say, Indigenous people on juries or racialized people on juries, what do you suggest is the way in order to see more of them represented?
Well, instead of turning to cheap political solutions like abolishing peremptory challenges, when, as I said, that'll have the opposite effect, the solution is to implement the Yakabuchi report, implement the dissent of the Supreme Court in the Coco Panas case that made it very clear this is a serious problem and requires serious resources. There needs to be intensive outreach to Aboriginal communities, both on a jury pool level, but also on a general level to ensure that you don't have these negative feelings and stereotypes persisting about the justice system. But that costs money, and it's expensive. It's something that a majority of the Supreme Court was not willing to do, was not willing to force Parliament to do that. What I cannot understand is why a party that drapes itself in the Charter of Rights and Freedoms didn't simply adopt the Yakabuchi report or adopt the minority of the Supreme Court and say, we can do things better. It's going to cost money. It's going to take effort, but we are going to bring in the underrepresented communities into the jury system. Remember, the government controls the jury roles. They select the jury. That's not something defense counsel does. Defense counsel only helps to pick part of the ultimate 12. But in terms of the people who are coming into the system, that's the government responsibility, and they have a responsibility to ensure that it's representative.
But why can't it be both? I mean, isn't this a beginning that you get rid of the peremptory challenges, but you also make it possible, you put up the resources in order to make more racialized people available to jury pools?
The trouble with getting rid of the peremptory challenge is that it lacks the counterbalance. You see, in other jurisdictions like the United States, they've struck a different bargain. They don't have, in most places, a peremptory challenge where you can challenge for no reason. But what they do have is they call it voir dire, where you can question jurors, ask them about their experiences, their bias, their backgrounds, what they know about the case. Very extensive questioning that really doesn't exist in Canada in a meaningful way. So it's one thing to get rid of the peremptory challenge and say it doesn't make sense, you don't have much information to work on, but you can't replace it with nothing.
We'll leave it there. Mr. Friedman, thank you.
My pleasure.
Solomon Friedman is a defense lawyer and managing partner at Edelson and Friedman LLP. He was in Ottawa.